When HOA President Karen Weatherby organized a massive community picnic on my private lake without permission, she thought she could bully me into submission. What she didn't know was that I'm a retired attorney, and her entire scheme was about to be exposed in the most devastating courtroom defeat imaginable. Before watching full story, comment below where you watching, also like and subscribe for more stories. The first time I met Karen Weatherby, she was standing on my dock at 6 in the morning, clipboard in hand, measuring the distance between my fishing chair and the water's edge. I'd been living peacefully on Clearwater Lake for 15 years, enjoying my retirement and the quiet sanctuary my late wife Emma and I had created together. What I didn't know was that Karen was about to turn my peaceful existence into a legal nightmare that would consume the next 6 months of my life. My name is Robert Chin, and at 68 years old, I thought I'd seen everything. 25 years as a corporate attorney had taught me to expect the unexpected, but nothing had prepared me for Karen Weatherby and her relentless campaign to steal my lake. "Excuse me," she called out in that sharp, authoritative tone that immediately put me on edge. "I'm Karen Weatherby, President of the new Lakeshore Commons Homeowners Association. We need to discuss the community use regulations for this lake." I set down my coffee cup and turned to face her. Karen was a woman in her early 50s with perfectly styled auburn hair and the kind of expensive workout clothes that suggested she spent more on athleisure than most people spent on their cars. She had that particular brand of aggressive confidence that comes from years of getting her way through sheer force of personality. "Community use regulations?" I asked, genuinely puzzled. "I'm sorry, but I think there's been some kind of misunderstanding." "No misunderstanding at all," she replied, consulting her clipboard with theatrical precision. "This lake falls within the boundaries of our homeowners association, and as such, it's subject to our community guidelines and usage policies." I couldn't help but smile at her certainty. "Ma'am, I appreciate your enthusiasm, but this is a private lake. I own it." Karen's laugh was sharp and dismissive. "Mr. Chin, I've done my research. This entire area was developed as a planned community with shared amenities. The lake is clearly designated as common property for the use of all residents." "And what research would that be?" She waved her clipboard triumphantly. "I have copies of all the relevant property surveys and community planning documents right here. The lake is listed as a shared recreational facility." I stood up slowly, my old bones protesting the early morning chill. "Mrs. Weatherby, I think you might want to double-check those documents. I've owned this lake and the surrounding property since 2008, long before any homeowners association existed." "That's impossible," she snapped. "The development company assured us that all amenities were included in the community covenant." "The development company?" I repeated thoughtfully. "That would be Sunset Properties, correct?" "Yes, how did you know?" "Because I sold them the land for the housing development. All of it except the lake and this 5-acre parcel I kept for myself." Karen's confident expression flickered for just a moment before returning to full force. "Well, even if that's true, you can't just hoard a community resource. The residents of Lakeshore Commons have every right to expect access to recreational facilities that were promised as part of their property purchases." "Mrs. Weatherby, I'm not hoarding anything. This is my private property, and I have every right to use it as I see fit." "We'll see about that," she said, turning on her heel and marching back toward the development. "The HOA board will be hearing about this, and I can assure you we won't stand for one selfish individual ruining things for the entire community." As I watched her storm away, I had a sinking feeling that this was just the beginning of my troubles. In my years as an attorney, I'd encountered plenty of difficult people, but Karen Weatherby had that special combination of entitlement and determination that made for a truly dangerous opponent. I was right to be worried. Over the next 2 weeks, Karen launched what could only be described as a campaign of harassment designed to force me to surrender access to my lake. It started with a formal letter from the HOA board demanding that I cease and desist from interfering with community members' rightful access to shared recreational facilities. When I ignored that letter, the escalation began in earnest. Karen organized community awareness walks that just happened to pass by my property at all hours of the day and night. She arranged for landscaping crews to accidentally dump grass clippings and yard waste along my shoreline. She even convinced the local fire department to conduct water access inspections to ensure my dock met safety standards for community use. But the final straw came on a Saturday morning in late May. I was sitting on my deck, enjoying my morning coffee and watching a family of ducks paddle across the calm water, when I heard the sound of vehicles approaching. Not just 1 or 2 cars, but what sounded like a small convoy. I walked around to the front of my house to find a dozen cars parked along my driveway and street. Karen stood in the middle of my lawn, directing traffic like she was running a major event. Behind her, I could see people unloading folding chairs, coolers, grills, and what appeared to be a complete sound system. What exactly is going on here? I called out, walking toward the growing crowd. Karen turned to face me with a brilliant smile that didn't reach her eyes. Oh, Robert. Perfect timing. We're setting up for the Lakeshore Commons' first annual Community Appreciation Picnic. On my property? Well, technically the lake belongs to the community, so we thought this would be the perfect venue. Don't worry, we'll clean up afterward. I looked around at the chaos unfolding on my lawn. Someone had already started assembling a large gazebo near my dock, while another group was stringing lights between my trees. A man I didn't recognize was testing a microphone and speakers that would have been appropriate for a rock concert. Mrs. Weatherby, I'm going to ask you once, politely, to pack up your things and leave my property. Oh, Robert, don't be such a spoilsport. This is about community building and bringing neighbors together. Surely you can spare a few hours for the greater good. This is private property and you're trespassing. All of you. Karen's smile never wavered. Actually, we've done our legal research and we believe we have every right to be here. The community covenant clearly states that shared facilities are for the use of all residents. I am not a resident of your community, and this is not a shared facility. We'll have to agree to disagree on that point. Now, if you'll excuse me, I need to make sure the catering table is set up properly. That's when I realized that Karen wasn't just stubborn or entitled. She was operating from a fundamentally different understanding of reality. In her mind, she had convinced herself that she was right, and no amount of reasonable discussion was going to change that. I pulled out my phone and called the non-emergency police line. Hi, this is Robert Chin at 47 Lakeshore Drive. I need to report a trespassing situation. 20 minutes later, Officer Martinez arrived to find what looked like a small festival in progress on my front lawn. Karen had somehow managed to organize face painting, a bouncy castle, and what appeared to be a DJ booth in the time it had taken for the police to arrive. Mr. Chin? Officer Martinez asked, consulting his notepad. You called about trespassing? That's correct. All these people are on my private property without permission. Officer Martinez looked around at the crowd, which had grown to include what appeared to be most of the Lakeshore Commons development. Ma'am, he called to Karen, can I speak with you for a moment? Karen approached with the confidence of someone who believed she held all the cards. Officer, I'm Karen Weatherby, president of the Lakeshore Commons HOA. I think there's been a misunderstanding. This is a community event on community property. Do you have documentation showing that this is community property? Karen produced a folder thick with papers. Absolutely. Property surveys, community planning documents, HOA bylaws, everything you need to see that this lake and surrounding area are designated for community use. Officer Martinez spent several minutes reviewing the documents while the crowd waited in tense silence. Finally he looked up. Mrs. Weatherby, these documents show the planned community boundaries, but they don't actually establish ownership of this specific property. Do you have a deed or title showing community ownership of this lake? Well, no, but the development company assured us. Ma'am, without proper documentation of ownership or right of access, I'm going to have to ask you and your group to leave Mr. Chen's property. This is ridiculous. Karen's composure finally cracked. We've invested months of planning into this event. We've spent thousands of dollars on catering and entertainment. We have over 50 families here who were promised access to community amenities. I understand your frustration, ma'am, but private property rights take precedence. You'll need to move your event to a different location. What followed was the most spectacular meltdown I'd ever witnessed outside of a courtroom. Karen began screaming about conspiracy theories, corrupt police departments, and wealthy individuals who thought they could buy their way out of community obligations. She demanded to speak to Officer Martinez's supervisor, the mayor, the county commissioner, and anyone else who might overturn what she saw as a grave injustice. The crowd, meanwhile, began to turn on her. Families who had brought their children for a fun community event found themselves packing up and leaving in embarrassment. Several people apologized to me as they walked past, clearly mortified by the situation. It took another hour to clear everyone off my property, and by the time the last car pulled away, I was exhausted and more than a little shaken. I dealt with difficult opposing counsel and unreasonable clients throughout my career, but this level of personal attack was something new. I thought that would be the end of it. I was wrong. Monday morning brought a certified letter from the law firm of Hutchins, Bradley and Associates, representing the Lakeshore Commons HOA. The letter informed me that I was being sued for interference with community property rights, breach of implied covenant, and intentional infliction of emotional distress. According to the lawsuit, Karen and the HOA board claimed that when I sold the land to Sunset Properties for development, I had implicitly agreed to provide lake access to all future residents. They argued that the community had been marketed and sold with the understanding that the lake would be available for recreational use, and that my refusal to honor this understanding constituted fraud and breach of contract. The lawsuit sought an injunction forcing me to provide community access to the lake, plus damages for the ruined picnic event and mental anguish suffered by community members who had been denied their promised amenities. I read the lawsuit twice, then called my old friend and former colleague Patricia Hawkins. Patricia had recently retired from her position as a senior partner at one of the state's most prestigious law firms, but she still took on select cases that interested her. "Robert," she said after I'd explained the situation, "this is either the most creative property rights case I've seen in years, or the most frivolous lawsuit ever filed. I'm genuinely curious to find out which." "So you'll represent me?" "Absolutely. This sounds like fun." Patricia's first move was to request all documentation related to the original land sale, the community development, and the HOA's formation. What we discovered was a web of misrepresentation and deliberate obfuscation that went far beyond Karen's personal delusions. It turned out that Sunset Properties had indeed marketed the Lakeshore Commons development with promises of exclusive lake access and waterfront community amenities. Their sales materials featured prominent photos of my lake and descriptions of planned community events and activities centered around water recreation. The problem was that Sunset Properties had never owned the lake or secured any rights to it. They had simply assumed that they could pressure me into providing access after the development was complete, or that they could purchase the lake from me at a below-market price once I was surrounded by their community. When I refused their initial lowball offers to buy the lake, they apparently decided to proceed with their marketing campaign anyway, hoping to create enough community pressure to force my hand. "Robert," Patricia said during one of our strategy sessions, "this isn't just about your property rights. This is about a development company that sold hundreds of thousands of dollars worth of property based on false promises, then left the community holding the bag when those promises couldn't be delivered. So what's our strategy? We're going to expose the entire scheme. And we're going to make sure that everyone who was defrauded gets the justice they deserve." The case took 6 months to work its way through the court system, but when it finally came to trial, it was everything Patricia had promised and more. She had subpoenaed records from Sunset Properties, interviewed dozens of Lakeshore Commons residents, and assembled a case that painted a clear picture of systematic fraud and misrepresentation. The star witness, ironically, was Karen herself. Under oath, she was forced to admit that she had never actually verified the community's ownership of the lake before launching her campaign against me. She acknowledged that she had organized the trespassing picnic despite knowing that I had explicitly denied permission. Most damaging of all, she admitted that she had continued to pressure me even after being shown clear evidence that I owned the property. But the real bombshell came when Patricia called James Hendricks, the former sales director for Sunset Properties, to testify. Under questioning, Hendricks revealed that the company had knowingly marketed lake access despite never having secured any rights to the property. "We knew it was a problem," he testified, "but management felt that we could resolve it after the lots were sold. The lake access was a major selling point, and removing it from our marketing would have significantly reduced our sales prices." "So you knowingly deceived purchasers about an amenity you couldn't provide?" Patricia asked. "Yes, ma'am." "That's an accurate characterization." The judge's ruling was swift and comprehensive. He dismissed all claims against me, finding that I had never made any representations about providing lake access and had consistently maintained my property rights. More importantly, he issued a permanent injunction prohibiting Karen and the HOA from trespassing on my property or interfering with my use of the lake. But Patricia wasn't finished. She filed a separate class action lawsuit on behalf of all Lakeshore Commons residents who had been defrauded by Sunset Properties' false marketing. The case settled 6 months later for $2.3 million, providing compensation to every resident who had purchased property based on the false promise of lake access. Karen never apologized, but she did resign from the HOA board shortly after the trial. Several neighbors told me that she had put her house up for sale and was planning to move back to wherever she had come from. The aftermath of the legal battle brought some unexpected benefits. Many of the Lakeshore Commons residents, once they understood the true situation, became friendly neighbors rather than adversaries. Several of them approached me privately to apologize for their role in the pressure campaign and to thank me for exposing the fraud that had cost them thousands of dollars. I even decided to open my lake to limited community use, but on my own terms. I established a small permit system that allows residents to use the lake for fishing and non-motorized boating, with clear rules about respect for the property and wildlife. It's worked out well for everyone involved. The most satisfying part of the whole experience was watching Patricia work. She approached the case with the methodical precision of a master craftsman, carefully building her argument piece by piece until the truth was undeniable. Watching her dismantle Karen's claims and expose the development company's fraud was like watching an artist at work. "Robert," she said after the final settlement was approved, "I have to thank you for bringing me this case. It reminded me why I became a lawyer in the first place." "And why is that?" "To protect people who are being taken advantage of by those with more power or resources. Your neighbor Karen thought she could bully you into giving up your property rights. Sunset Properties thought they could commit fraud and leave the community to deal with the consequences. They were both wrong." As I sit on my dock now, watching the sunset paint the lake in shades of gold and crimson, I'm reminded of something Emma used to say: "The truth always comes out in the end, but sometimes it needs a little help." Karen Weatherby learned that lesson the hard way. She thought she could demand what wasn't hers and use community pressure to steal my property. Instead, she ended up exposing a fraud that had cost her neighbors thousands of dollars and destroying her own credibility in the process. The lake is peaceful again, visited only by the occasional permitted neighbor and the wildlife that has always called it home. Sometimes I think about what would have happened if I had just given in to Karen's demands, if I had decided that fighting wasn't worth the trouble. But then I remember Emma's words about truth needing help, and I'm glad I chose to fight. Not just for my property rights, but for the principle that bullies shouldn't be rewarded and that communities are stronger when they're built on honesty rather than fraud. The Lakeshore Commons development is thriving now, populated by neighbors who understand and respect property boundaries. Karen's house sold last month to a young family with 2 children who love to watch the ducks from their backyard. They've never once suggested that they have any right to use my lake, and I've never once felt the need to deny them the simple pleasure of enjoying the view. Sometimes the best revenge is simply living well and letting the truth speak for itself. Karen Weatherby learned that lesson too late, but at least she learned it. And in the end, that's probably the best outcome anyone could have hoped for.